Okay, so we were dealing with the free movement of services within the European Union. We said that the rights conferred on service receivers and service providers may be divided into three. First, we spoke about the rights of departure, entry and residence. Second, we started speaking about rights of access to the market in service in other member states. The right of access to the market in services in other member states. There we spoke about the distinctly applicable measures, which was provided under Article 57 of the Treaty on the Functioning of the European Union, which prohibits discrimination on the ground of nationality. Therefore, in other words, which prohibits discrimination, direct discrimination. Secondly, we spoke about indistinctly applicable measures. When I say indistinctly applicable measures, what would you understand? Yes, Deniz?
I mean, the measure doesn't involve domestic or imported products.
Services.
But it just, creates discrimination whether or not it is imported or,
That is for the goods. Now we are in services. In this, yes. Okay.
Impose additional burden on foreign service providers.
Exactly. There is no clear indication to that, but still, indirectly, they establish an additional burden on foreign service providers. This would breach also Article 56 of the Treaty on the Functioning of the European Union, unless it is justified by overriding reasons of public interest. And as an example, we gave Commission versus Germany as regards insurance cases. According to the decisions of the Court of Justice of the European Union, the measures which are not directly or indirectly discriminatory may still breach Article 56. Therefore, here as well, we speak about measures liable to prohibit or impede the activities of a service provider. The measures liable to prohibit or otherwise impede the activities of a service provider may still breach Article 56. These requirements or these measures apply to everyone without distinction or without making any distinction to national providers of services. Therefore, these measures, these national rules, apply to both national service providers and service providers of other member states equally. But still, as long as they restrict the activities of a service provider, they are considered as against Article 56 of the Treaty on the Functioning of the EU. For instance, the authorization requirements or registration requirements or a national rule which prohibits advertising are considered within this third group by the Court of Justice. Therefore, against the free movement of services. The third group of right considered within free movement of services is the exercise of rights. We spoke about the rights of departure and entry. We spoke about the access to the market. And third, we will be speaking about exercise of the rights to provide or receive a service. In this area as well, direct and indirect discrimination, as well as the measures or any other measures which would restrict the exercise of the freedom to provide or receive services are prohibited by the Court of Justice. First of all, the Court of Justice interprets Article 56 as including the principle of equal treatment as regards the terms and conditions on which the service is provided or received, as well as equal treatment in respect of social and tax advantages. Therefore, direct discrimination is prohibited by Article 56 as regards the exercise of the rights to receive or to provide services. An example was in the decision of Commission versus Spain, where the Spanish rule, the Spanish law, provided for free admission to state museums for Spanish nationals and foreigners resident in Spain. At that time, the Spanish law provided for a rule which provided a free admission of Spanish nationals as well as the residents living in Spain for free, but not to tourists. The Commission pointed out that visiting museums encourages tourists, and tourists are accepted as receivers of services to go to another member state. Therefore, according to the Commission, there was a close link between free movement and museum admission. And the court ruled that the Spanish rule conflicted with Article 56 of the Treaty on the Functioning of the EU. At that time, it was Article 49.
Which year was that? I mean, in 19 or in 2000?
It was, I had to look and tell you, all right? Second, indirect discrimination is also prohibited. It was in De Koster in 2001, where a Belgian tax on satellite dishes encouraged the subscribers to receive their programs by cable instead. There was a tax applied on satellite dishes according to a Belgian tax rule, which encouraged the subscribers to receive their programs by cable instead. Because the Belgian distributors had unlimited access to cable distribution, the court found that this rule had a particular impact on the broadcasters established in other member states, which could be received the programs only by satellite. And it found that although this rule was not directly discriminatory, it was still indirectly discriminatory, since it makes a difference on national and non-national broadcasters, and it puts an additional burden on the broadcasters living in other member states. Thirdly, measures liable to prohibit or impede the exercise of the free movement to provide or receive services is also prohibited. Here there is no discrimination again. No direct discrimination and no indirect discrimination. But there is a restriction by the national law to exercise the free movement or the freedom to receive or to provide services. An example is a decision of the Court of Justice in Sea Land Service in 2002. In this dispute, the Dutch authorities levied a tariff, applied a tariff to cover the costs of navigation services. Charge on sea-going vessels. In Turkish? Sea-going vessels? Deniz araçları. But not on inland waterway vessels. Inland waterway? This is for next week homework. Okay? Therefore, the Dutch, in the Dutch rules, there was difference between inland waterway vessels and seagoing vessels in terms of the tax that was applied. Sealand argued that the tariff was indirectly discriminatory because most of the inland vessels or inland waterway vessels were Dutch. The court found that there was no discrimination because two different means of transportation were not comparable. The tariff imposed on seagoing vessels was liable to restrict the provisions of services, at least to render the provision of services less attractive. Therefore, there was a breach of Article 56. This is how the provisions of the founding treaty, the primary legislation, was interpreted by the Court of Justice. The free movement of services today is provided also by the Services Directive. This is the main secondary legislation, or the Directive 2006/123. I'm not going to speak in detail about this directive, just to mention you the importance and the purpose of the directive. The Services Directive is the secondary legislation as regards the free movement of services. Its purpose is to facilitate the cross-border provision of services within the European Union. It sets out what kind of restrictions the host member state may still impose. This is provided under Articles 16 and 17 of the directive. Please read those provisions we mentioned in class. It also provides what type of supervision can be exercised either by the state of establishment or by the host state. These two alternatives are provided under Articles 30 and 31 of the directive. Under the directive, the member states are required to simplify their bureaucratic procedures as regards the exercise of the right of establishment and provision of services. The directive also requires the member states to establish single point of contacts so that the service providers from other member states need only to address themselves to satisfy the requirements of that member state to provide services in that member state. Therefore, they establish single point of contacts in every member state. If you would like to provide services in that member state, it is enough, if it is sufficient if you contact with that single point of contact and learn the procedures, the requirements, satisfy them to exercise the right of free movement of services. This directive only applies where other directives, which are more specific, or regulations do not apply. Okay, please read about the Services Directive in your book chapters as well. Any questions? Since the start of this semester, we spoke about the origins of the EU. We spoke about widening, deepening. We spoke about the institution of the EU. We spoke about the sources of European Union law. We spoke about the competences of the European Union. We spoke about the actions under the jurisdiction of the Court of Justice. Then free movement of goods, free movement of services, and free movement of workers. The last bit, which is related to the second course, is the area of freedom, security, and justice. In Turkish, the area of freedom, security, and justice. Exactly, the area of freedom, security, and justice. The EU today has an aim to establish an area of freedom, security, and justice. It is provided under the EU Treaty as well as under the Treaty on the Functioning of the European Union. This is a very important aim, objective for the European Union. It is provided even before the aim of establishing an internal market in the founding treaties today. Therefore, under the Lisbon Treaty today, this aim is even more important, we can say, than the aim of establishing an internal market. The provisions on the area of freedom, security, and justice provides 4 different topics, which you will be seeing. The first is the policies of asylum in Turkish. Asylum, iltica, border checks, and immigration. Immigration? Göç. The second is the judicial cooperation in civil matters. In the judicial cooperation in civil matters, there are the regulations of the EU on private international law. So it is very related to us as well. The judicial cooperation in criminal matters. And lastly, the police cooperation. The European Union has a power to adopt binding instruments in the area of immigration, asylum and immigration, since the Treaty of Amsterdam. until the Treaty of Amsterdam, this was seen as an area under the competences of the member states. But the Amsterdam Treaty made important changes in the whole area of freedom, security, and justice. And therefore, after the Treaty of Amsterdam, gradually the EU has started to adopt legally binding acts for the member states. But attention, there is an important exception, derogation, in the area of freedom, security, and justice. The UK, Ireland, and Denmark have special positions in the area of freedom, security, and justice. At the beginning, Denmark opted out. Opt out? Exactly. Denmark at the beginning said, I'm not in, I'm out. And there is no possibility for Denmark to opt in again legally, okay? So the instruments adopted in this area are not applied to Denmark anyways. The UK and Ireland also opted out with the possibility of opted in. So if you want to find out whether a piece of legislation in the area of freedom, security, and justice is applied in the UK, for example, you have to look specifically for the territorial application of this instrument. In some, the UK opted in. In others, the UK has not opted it yet. All right? Denmark does not want to opt in for the legislation in this area. So if the EU or if Denmark decides this legislation for it to apply, it has to make an international agreement. So the legislative instrument would be different. So in the second semester, in the course on European and international migration law, which is not specific to EU, attention, we will be speaking about international aspects of migration as well. We will be speaking about what is a migrant, what is a refugee or who is a refugee, what is international protection, what is temporary protection. We will be speaking about main international instruments in the area of immigration, asylum and immigration, and then we will move to the EU instruments. And as you will be seeing, the topic immigration is divided into different subtitles. For example, as far as the EU is concerned, we will be first dealing with legal migration and integration. Legal migration and integration. In Turkish? Yasal göç ve entegrasyon. What do I mean when I say legal migration? Which is not illegal.
Maybe.
Sorry?
For example, when the migrants go to European Union, if there's an agreement, they are accepted by the legal aspects.
No.
Registered.
They go according to law. You have a valid passport, you have a valid visa, you go according to the law. What rights do you have?
So we are, for example, legal migrants, when we are first.
You will speak about that. Which rights do you have? Can you study? Can you work? What are the directives providing rules for legal migrants in the EU? Second, we will be speaking about irregular migration. Irregular migration? Düzensiz göç. If the migrants are living in the EU, working in the EU, contrary to the EU legislation, they may be in a position of legal migrants. Which provisions are applied to them? And then we will come to the situation of the Turkish nationals in the European Union, because we have a special agreement with the EU. And then we will also speak about the jurisprudence of the Court of Justice as regards the Turkish citizens. And of course, we will speak about the readmission agreement between Turkey and the EU and the visa liberalization process. Therefore, I will divide the course in the second semester as international aspects of migration, the first 7 weeks, and European aspects of migration in the second 7 weeks of the term. All right? Okay, I thank you very much for this super productive first term. I'm very happy to meet you all, that I had the opportunity to teach you, and I hope to see you again in the second semester. All right?